Naomi SS, faculty member, Department of Environmental Sciences, University of Kerala. So on behalf of organizing committee, I welcome Srimati Naomi SS to this program. Also on behalf of organizing committee and University of Kerala, I welcome Shri Thrideep Kumar MP, environmental engineer, Kerala State Pollution Control Board, to this program. Also, I welcome all the participants to this program. Now I invite Srimati Naomi SS to chair the session and the proceedings regarding this morning session. Thank you. Naomi, please.
Thank you, sir. Thank you, sir. Good morning, all. Today we have an eminent personality, Shri Thrideep Kumar MP, with us. He has completed his BTech in Chemical Engineering in TKM College of Engineering and MTech Biotechnology from Javadpur University, Calcutta. He has a working experience of 24 years in Pollution Control Board. Currently, he is working as Environmental Engineer, Kerala State Pollution Control Board, Thiruvananthapuram. Now he is going to deliver a lecture on the topic hazardous waste management. With great pleasure, I invite you, sir, for delivering the session. Thank you all.
We can start. Sir. Can I start? Can I speak?
Yes, sir, you can start now.
Good morning, everybody. Respected Professor Dr. Sadam Yanatanga, convener and head of the Department of Environmental Sciences, University of Kerala. Respected Sabu Joseph, sir, who is the organizing secretary of this Silver Jubilee celebration of the department. Dr. Jaya, Dr. Vindya, Simali Navami, and dear students. We know the present time is of dispute, conflicts, and confrontation. Everybody agree. But all will agree in one thing. No dispute or disagreement on the matter of the extreme essentiality of pollution or protection of environment, including pollution control. Why it is so much significant? It is very well highlighted in all the World Environment Days, especially in the theme of slogan of 2015 World Environment Day. That is 7 billion people, one planet consumed with care. In fact, it is 7 billion dreams, one planet consumed with care. What we lack, even though we have innumerable number of actions, activities, acts, rules, orders, notifications, statutory and other institutions, NGOs, sports, seminars, workshops, and now, because of COVID, webinars, what we lack. In my 24 years of experience as a law enforcing officer in this statutory organization in the field of pollution control board, that is KSPCB, I realized, experienced, and now voicing very high pitch the root cause. It was really according the first International Convention on Human Environment, that is 1972 Stockholm Convention. The one sentence of the gist of the convention is develop a universal culture to respect global environment. Develop a universal culture to respect global environment. So we can start with respect together the environment. Okay, we can now have the slides. For the 25th year of, that is Silver Jubilee celebration, you are conducting the solid waste management seminar on solid waste management. And I think already from the pollution ground, my colleagues conducted or they delivered on solid waste management and biomedical waste management. There are 6 waste rules that was promulgated in or re-promulgated, it is correct, by the Parliament in 2016. 6 waste management rules: solid waste management rules, plastic waste management rules, e-waste management rules, biomedical waste management rules, construction and demolition waste management rules, and hazardous waste management rules. So this hazardous waste management rules first came into this country in 1989. Before that, there are 3 acts. The first environmental legislation passed in this country is Waste Water Prevention and Control of Pollution Act, in short, Water Act, that was promulgated in 1974. Then came the similar act, Air Pollution and Air Prevention and Control of Pollution Act, in short, Air Act, in 1981. Then after 1984, there was a huge, great disaster in the country. You know that Bhopal gas tragedy. Around 16,000 people died. And after that, the rulers of the country think of an act, because for controlling this pollution so far, that means that 1974 to 84, there was only 2 acts, Water Act and Air Act. And this Bhopal gas tragedy actually didn't come this acts. So they think of an umbrella act, Environment Protection Act. Along with the EP Act came EP rules. And under this Environment Protection Act and EP rules, the Parliament passed Hazardous Waste Management and Handling Rules 1984. And it was amended in 2000 and 2003 and re-established another act, a new act, Hazardous Waste Management and Transboundary Movement Rules 2008. Then again a new rules, Hazardous and Other Waste Management and Transboundary Movement Rules, HOWMTM. Why this hazardous waste is so much important? Because hazardous waste poses threat to the environment and human health. Depending on the nature and volume of the hazardous substances and the receiving environment, the improper management of this waste causes very adverse or lethal effects on humans, animals, and plants. What are the effects? These include mortality, adverse effects on reproduction, causing cancer, causing deformities and genetic mutations, causing other diseases, accumulation in the environment and living tissues. And also this may have consequences in the food chain and indirect effects on ecosystems. Hence, hazardous waste requires adequate management. In our country, there is a generation of huge quantities. It is estimated as 4.2 millions. That is few years back. Now it is more than that. Hazardous waste contains complex chemicals. Actually, I have already told the Bhopal accident focused government attention on hazardous waste management. That was one of the worst industrial disasters, not in the history of this country, in the world. And the act of these rules is Environment Protection Act 1986. It defined environmental pollution means the presence in the environment of any environmental pollutant, and the act itself defined environmental pollutant any solid, liquid, or gaseous substances presented in such concentration as may be or tend to be injurious to the environment. How the government established or passed these rules and acts, because Section 6 of Environment Act, Environment Protection Act, Environment in Protection Act, Paristhiti Samrakshanam. Section 6 of EP Act provide powers to the government to make rules for providing procedures and safeguards for handling hazardous waste and prevention of accidents. And according to that section, those persons who can carry hazardous waste only in accordance with procedures and safeguards prescribed. They can handle and manage, but according to the procedures and safeguards prescribed by the rules. Section 25 of the Act gives the power of central government to make rules for the protection and improvement of environment. And structure of these acts. Every act or rules have a preamble, then a short title, it is its name, definition, authority, organization, then functions of organizations, functions of various agencies, then penal provision, then any aggrieved person can appeal, so appellate and appeal. So total hazardous waste generation 42 lakhs or 4.2 million tons per annum, and 80% of the total hazardous waste generated in the country is from 4 states: Maharashtra, Gujarat, Andhra Pradesh, and Tamil Nadu. And 2/3 of the remaining 20%. So 80% from 4 states and 2/3 of the remaining 20% is from 6 states. So 90% of the hazardous waste generated in the country is contributed by 10 states. And about 20% of the remaining 10% is by our states. It's less than 2%. Because there are 42 lakhs, 4.2 million tons of hazardous waste generated in the country, and Kerala generates less than 80,000, that is less than 2%, 72,000 the last years. So this also I have mentioned. The hazardous waste management and handling rules came into effect in the country in 1989. It was amended in 2000 and 2003, and 2008 a new rules, because the name itself changed. Hazardous waste management, hazardous waste management handling of transport movement rules. In 1989, there is a ministry for this environment protection and pollution control. That is Central Ministry's Ministry of Environment Forest. It was initially so. So now it is Ministry of Environment, Forest and Climate Change. From 2014 onward, the ministry included climate change also. So in 1980, there is the ministry promulgated hazardous waste management and handling rules. 1989. under the provisions of the AP Act, it was amended in 2008 to incorporate Basel Convention provisions. Because all these Environment Protection Acts and rules are according to the constitutional framework and also our country's commitment to the international conventions. One such convention is Basel Convention on Transboundary Movement of Hazardous Waste that was held in 1992. India is also a signatory to the convention. So the 1989 rules have been further amended in 2008 to incorporate the Basel Convention provisions. In 2016, it was further amended as hazardous and other waste, not hazardous waste alone. Hazardous and other waste management and transboundary movement rules 2016 include other waste such as waste tire, paper waste, metal scrap, used electronic items, etc. So this hazardous waste is regulated in our country by Ministry of Environment and Environment, Forest and Climate Change, Central Pollution Control Board, and State Pollution Control Boards. In our state, it is Kerala State Pollution Control Board and also Pollution Control Committees. That is not in union, that is for union territories. There it is not Pollution Control Board, Pollution Control Committees. So the objective of the hazardous and other ways management and transboundary movement rules to ensure appropriate collection, reception, treatment, storage, and disposal of hazardous waste. That was listed in the schedules 1, 2, and 3 of the rules. And also the regulation of transboundary movement as per the decisions of the Basel Convention on transboundary movement of hazardous waste is another objective. Import of, as per this convention and this rule, import of hazardous waste is permitted, but only for reprocessing, not for disposal. So reprocessing is for obtaining these useful products. So its dumping is prohibited. So for dumping, we cannot import waste from it. Because these rules and convention came because of developed countries. Developed countries, there were instances of dumping, illegal transporting of hazardous waste from developed countries to some undeveloped countries. So this convention was started because of that. The handling and management of waste generated are to be primarily regulated by the pollution control boards in accordance with the guidelines of Ministry of Environment, Forest and Climate Change and also by Central Pollution Control Board. So this is the Basel Convention. These rules I have already mentioned, hazardous waste management and handling rules 1989, an amendment. Hazardous waste is defined by the rules as any waste which by reason of any of its physical, chemical, reactive, toxic, flammable, explosive or corrosive characteristics cause danger or is likely to cause danger to health or environment, whether alone or when in contact with other waste or substances, and shall include waste specified in column 3 of Schedule 1. And we will see later. Waste having constituents specified in Schedule 2 if their concentration is equal to or more than the limit indicated. Also, waste specified in Part A or Part B of Schedule 3 import or export of such waste.
Thrideep sir?
Yes.
Yeah, sorry for the interruption. You can ask the our Vishnu to move the slide because once it is over. Okay.
Okay.
Because otherwise he will not be knowing the content. What will be the next slide? You can move the slide based on which he can move the slide. Okay. Thank you, sir.
Now we are in slide 21. Vishnu? Hello, Vishnu?
Vishnu, please take 21, slide number 21. Is it okay, sir?
21. Correct.
Okay.
So
You please tell Vishnu to move the slide, sir. Otherwise, he will be in trouble.
Okay. So hazardous waste is a waste according to this rule. Either a characteristic waste, that is hazardous characteristic, that was listed in the rules itself, or a listed waste. Characteristic waste exhibits at least one of the 5 characteristics: flammability, explosivity, corrosivity, toxicity, or carcinogenity. And wastes are listed in Schedule 1 and 2. Slide 22. Hazardous waste covered, even though it is hazardous in nature, if the waste is covered under Water Act and Air Act, it is not coming in these rules. Radioactive waste, that is covered under Atomic Energy Act and Atomic Energy Commission. They are handling this, not pollution control boards or CPCB. And waste covered under biomedical waste management rules. That is not coming. In these rules, the rules mentioned biomedical waste, municipal solid waste, these rules are now re-promulgated as in 2016, because it is coming in the 2016, this hazardous waste, hazardous and other waste management and transboundary movement rules came some days before all these rules, because it came into effect in 4th April, and all other rules of 2016 came after 4th April. So it was mentioned in these rules as biomedical waste management rules 1990. In fact, it is biomedical waste management rules 2016 and municipal solid waste 2000. It is now solid waste management rules 2016, and these rules were covered by my colleagues, Dr. Shri and Pamela. And also waste arising out of operation of the ship, that was covered by Merchant Shipping Act. That act is before all these environmental legislations, 1958 Merchant Shipping Act. So these waste not handled in this, not managed in this HOWMGM rules 2016. Next slide, 23. These are the schedules. So what is handled in these schedules? Schedule 1, list of processes generating hazardous waste. There are 36 processes in this 36 processes, there are 128 categories of hazardous waste. Then list of waste constituents with concentration limits. And list of Schedule 3 is about list of waste applicable for imports and exports. Only those wastes covered in this list can import and export. Schedule for list of hazardous waste requiring registration for recycling or reprocessing. Then Schedule 5, specifications of used oil suitable for reprocessing or recycling. Some hazardous waste are permitted for reuse and recycling. So, in the case of used oil, Ministry of Environment, Forest, Climate Change and CPCB, after study, they put some specifications for used oil. And if the specifications are met, those used oil can be reprocessed. And Schedule 6, those wastes cannot be imported or exported because these rules prohibited those wastes. And Schedule 7, authorities and corresponding duties, including CPCB, KSPCB, customs, etc. So, slide 24, Vishnu. Schedule 1 related to specific waste identified for specific process. Cleaning, maintaining, and emptying of petroleum storage tank, including ships. There the specific waste is residual, fragile, ballast water. Petroleum refining, reprocessing, recycling of waste oil. There the specific waste is organic residue, oily sludge, and in industrial operations in mineral and synthetic oil, they are the used or spent oil. And another unit process producing hazardous waste purification and treatment of exhaust air, water and wastewater from processes and CETPs, common effluent treatment plants. Then hazardous waste, ash, distillation residues, spent acid from battery, blood from scrubbers. Slide 26. There is the applicability of Schedule 1. The inclusion of waste contained in this schedule does not preclude the use of Schedule 2 to demonstrate that the waste is not hazardous. So, for determining the concentration of hazardous constituents in the waste, the test is TCLP. Schedule 2, list of waste constituents with concentration limits. And an elaborate list is given in Schedule 2. List of TCLP test limits also mentioned. Schedule 30. That is already discussed. So, slide 31. Here are the rules. Define certain terms. Every rule define the terms used in occupier, means person who has control over the all aspects of the generation, then storage, transport, processing, disposal. If the person has the control, then he is the occupier, operator of the facility. And any person who owns or operates a facility for collection, reception, treatment, storage, and disposal. then importer, exporter, those who import and export, transporter, person engaged in the transportation of hazardous waste. Slide 32. Then this hazardous waste applicable to who? Applicable to occupier who generates, store, treat and dispose hazardous waste. This rule is applicable to operator who operates a facility, and also persons engaged in off-site transportation of hazardous waste. Then any person who imports hazardous waste, person who exports hazardous waste. Then one more person, recycler, reprocessors, who procures and processes hazardous waste for recycling, for recovery, or reuse. So this hazardous and other waste management and transboundary movement rules 2016 is applicable to the occupier, operator, and transporter, importer, exporter, and recycler or reprocessor. And the rules stipulated responsibilities for all these 6 management and all these 6 persons who manage hazardous waste. So responsibilities of occupier. Safe and environmentally sound handling of hazardous waste. Send or solitary estates, recycler or reprocessor or reuser or be disposed of in an authorized disposal facility. And the guidelines for this are determined by the SPCB as per the guidelines of CPCB and MOU. So the responsibility of the first responsibility of the occupier is to obtain authorization from the State Pollution Control Board. Then maintaining records of hazardous waste handled, name of the waste and quantity. Then they have to submit annual returns in specified form, that is form 4 to the regulatory authority, the State Pollution Control Board. Then actual management of the hazardous waste, that is take steps for reduction and prevention of the waste generated, recycling, its reuse, according to the conditions specified in the authorization given by SPCB to the occupier. Then if there is a record of sale, transfer, storage, recycling, that has to be maintained. Then they cannot pack, label or the containers in their system. There is specified system, packaging, labeling of containers as per Form 12. There is also a manifest system because they have to keep a manifest for transport to ensure proper disposal in specified in particular colors. Provide transporter with the relevant information in Form 11. That is also their responsibility. And if there is any accident, that has to be the Pollution Control Board in a specified form, Form 14. They are also responsible for damages, if any, caused to the environment resulting due to improper handling and disposal of hazardous waste. And also that responsibility includes compensation, also liable to pay financial penalties for any violations of the provisions under the rules. Slide 36. Who needs authorization? Occupier, operator, transporter, recycler, reuse, goes for reuse, importer, exporter. And the occupier or any person handling hazardous waste or other ways need to apply in Form 1 to the State Pollution Control Board. And the State Pollution Control Board give authorization under Rule 5 of the rules, and also that is in Form 2. If any person apply in Form 1 to the State PCB, assuring that they have facilities and they will and the facilities are adequate, the State Pollution Control Board will issue authorization within a specified day, that is within 120 days in Form 2. And if facilities are not satisfied, application will be refused. And those persons who engage in handling hazardous waste has to renew the authorization, that also in Form 1. Slide 39. And for transporters, there is CPCB guideline for packaging and label, and the transport is regulated by Motor Vehicles Act. And they have to keep Form 11, and they have to provide that Form 11 to the regulatory authorities. And transport of hazardous waste to another state for disposal, NOC from or authorization from both state PCBs shall be obtained. And also the occupier has to intimate the state PCBs before transfer of waste to transport. Slide 40. Yes, next one. There is manifest system that also I mentioned. And slide 43. These are the copies of manifest. And in white colored, an occupier to PCB. Yellow color, that occupier has to give to the transporter. And pink color manifest to transporter to operator. And orange color, operator to transporter. And green color, operator to PCB. And blue, operator to occupier. So this 6-colored manifest system is maintained. This is also about manifest. When will the regulatory authority, State Pollution Control Board, suspend or cancel authorization? That power is given by Rule 6. If the authorizee or person who obtained authorization failed to comply with the conditions of authorization, means failed to comply with any provisions of the Act or rules, first they'll be given a hearing and recording reasons, the authorization will be suspended or cancelled. Then, how long the hazardous waste can be stored? That means without processing or disposal or recovery or recycle. How long? That is as per Rule 7. No occupier, recycler, reprocessor, reuser, and operator can store hazardous waste beyond 90 days. But SPCBs may extend this period if there is sufficient reason and if the circumstances is eligible for extension. the state board has the state PCB state power. And one such case is small generators. It's very few quantity of hazardous waste. Then every time it cannot be, it is economically also feasible to give to the facilitator. So small generators up to 10 per year. Then recyclers, reprocessors and operators up to 6 months of their annual capacity. Then generators who have no access to any TSDF. TSDF is temporary storage and disposal facility. Here in Kerala, we have one that we will handle later in this slide itself. And waste which need to be specifically stored for development of a process for its recycling or reuse. In these 5 cases, SPCBs can extend the period of 90 days, beyond 90 days. Slide 46. Then, after, as per Schedule 4, hazardous waste in Schedule 4 can be recycled, reused, or reprocessed after getting registration from CPCB. So they have to apply in Form 5, and CPCB will evaluate the waste and verifying that or ensuring that the waste can be recycled, reused, or reprocessed, and they will give the authorization permit for recycling or reuse. There are also specific times CPCB shall dispose the application within 120 days.
Sir, excuse me, sir. Can you louder, please? Some audience, it's not audible. Can you
Yes.
louder? Little more. For me, it is clear, but some audience, there is a question, comment in the chat box that you are not audible, something like that. So little bit.
Okay.
Okay, sir. Keep the mic close to you. Okay. As possible. Okay. Thank you, sir.
Just like SPCB, the CPCB also has the power to suspend or cancel in case of non-compliance with the conditions of registration. In the case of authorization given to reuse, recycle, reprocessing, etc. And also in a legal manner, after giving a hearing and recording the reasons for suspension or cancel, CPCB can cancel or suspend the authorization. This is an algorithm for procedure for registration of recyclers and re-refiners. If the waste is specified under Schedule 4, then fit for case under Rule 8. That is, they are fit for applying authorization. If the waste is waste oil or used oil, then also it is fit for applying authorization. If it is not a waste oil or used oil, not applicable under the same rule, so that has to be disposed in a safe and sound manner. Then import and export, that is as per rule 12 and 13 of the HOW NTM rules. As I have already told, hazardous waste for disposal, not permitted. For disposing in this country, it can't be imported. And also for disposing any other country, we won't permit export. So hazardous waste for disposal, not permitted for import and export. It is permitted only for recycling or recovery or reuse. That is for generating some new products from the hazardous waste. Then hazardous waste, certain waste specified in the rule itself in Schedule 6, those wastes are not permitted for import or export. And this import and export, not SPCB or CPCB are the nodal agency. MOEF and CC now. Ministry of Environment, Forest and Climate Change is the nodal agency for import and export. So, for giving clearance or permit by MOEF, they will ask for authorization from SPCB or registration from SPCB and CPCB. So, SPCB, Ministry of Environment, Forest, Climate Change, Port Authority, Customs Authority, these are the agencies giving permission or consent. So, import, export for recycling, recovery and reuse. Yes, already mentioned. Hazardous waste in Part B of Schedule 3, not require prior consent of the country from where it is imported. Hazardous waste not in Part A and Part B of Schedule 3, but having characteristics in Part C, require permission from the central government. Schedule, slide 53. Procedure for export from India. Those who intend to export from India shall apply in Form 7 and Form 82, Ministry of Environment and Forest and Climate Change, with insurance and prior informed consent from importer. And this MOEF will forward the NOC given to SPCB and CPCB, Ports and Customs, because these agencies have to ensure compliance of conditions for safe handling of the waste in the shipment, waste shipment. And also shipment is accompanied with movement document. And in the case of export, exporter shall inform the ministry on completion of transboundary movement. Similar procedure for import, apply in Form 7 and Form 82, the ministry with prior informed consent from exporter, and copy to SPCB for comments from MOEF. And the customs will take a random sampling of consignment, because to ensure the compliance of the rules. Slide 54. This is handling or illegal management of hazardous waste, illegal traffic. The export and import of hazardous waste from and into India shall be deemed illegal if it is without permission of the central government, that is without the NOC from Ministry of Environment and Forest. Or it is illegal if the permission has been obtained through falsification or misrepresentation. That is also illegal. Even though they have even if they have NOC from ministry, and if they do not conform to the shipping details provided in the movement document, then also it is illegal traffic. And they comply the NOC and the shipping details, etc. And they deliberate dispose or they're deliberately dumping, then also it is illegal. That is a contravention of the Basel Convention. So our country is a party to the convention. And in case of illegal import of hazardous waste, the importer shall re-export the waste with his own cost within a period of 90 days. So if there is illegal import of hazardous waste from any country to our country, the importer shall re-export at his cost within 90 days. So these are the duties of various agencies. Ministry of Environment, Forest and Climate Change, their duties: identification of hazardous waste, permission to exporters, permission to importers, permission to transit of hazardous waste through India. Then they have the responsibility. I think all authorities have this responsibility: training and awareness creation. CPCB, they are the coordinators. CPCB has to coordinate not only in this case, in all environmental legislations. CPCB has this responsibility: coordination of activities of SPCBs and pollution control committees, and conduct training courses for authorities dealing with managing hazardous waste. That is also their general duty, not only limited to hazardous waste. Recommend standards and specifications for treatment and disposal of waste. That also general, not limited to hazardous waste. Sector-specific documentation to identify waste stream for inclusion in hazardous waste rules. Vishnu? Hello, Vishnu?
Sir, which slide?
Slide 56.
66.
56.
56. Okay.
Yes. And this guidelines preparation is also the duty of CPCB. Then registration and renewal of registration for recyclers or re-refiners. And the duty of state government: identification of sites for CTSDA. Common temporary storage and disposal facility. And duty of the state government is assess CA report and convey the decision of approval of site. Otherwise, then land acquisition for sites, notification of sites, publish periodical inventory. Duty of SPCB, State Pollution Control Board. Here, the duty of Kerala State Pollution Control Board: inventarization of hazardous waste in the state, then grant and renewal of authorization, monitoring of compliance of authorization, including exports and imports, then examining the application for import submitted and forwarded the same to Ministry of Environment, Forest and Climate Change. Implementation of program to prevent, reduce, minimize the generation and handling of hazardous waste. Then another one, action against violators of hazardous waste. Next slide, 58. Directorate General of Foreign Trade. Their duties grant license for import of hazardous waste. Also refusal of license in case of import and export of prohibited hazardous waste. Then another important agency is Port Authority and Customs Authority. Their first duty is verify the documents, whether they have authorization, permit or license from all the concerned authorities. If there is any illegal traffic, like Port Authority and Customs have to inform the MOF and also to other agencies also. Analyze waste permitted for imports and exports. Training, that is the duty of all agencies. Then take action against export-import violations. Slide 59. There are 15 forms specified in the HOW MTM rules 2016. You have already mentioned form 1 is the application of for authorization from SPCB. 2 is the form for grant of authorization. The Kerala State Pollution Control Board is giving authorization in this form 2. And form 3 is for maintaining records. Form 4 is for submitting annual report by the operator or occupier to SPCB. Form 5, that is application. Form 1 is application for SPCB, and Form 5 is application for grant or registration for reprocessing to CPCB. And Form 8 is authorization by SPCB in that form, and Form 6 is Form 6 is filing annual returns by recyclers to SPCB. Oh, there is a mistake. Form 4 is the annual return form. Form 6 is the form for grant of authorization by CPCB according to Form 5 application. So Form 7, application for import or export. Form 8, application for transboundary movement for hazardous waste to Ministry of Environment and Forest. Form 9 is the document. The occupier or transporter has to keep transboundary movement document. Form 10 is that has to be maintained by the importer and exporter. Format for maintaining records of hazardous waste, import and export. Form 11, front card. Form 12, marking of hazardous waste container. Form 13, hazardous waste manifest. That we have seen in 6 colors, white, green, etc. Form 14, format. There is a format to report accident to SPCB and PCC. Then Form 15 is the appeal form. Appeal against any order passed by CPCB, SPCB or PCC. So slide 60, that is already mentioned. TSDF for hazardous waste. If the hazardous waste is not fit for recycle, reprocessing or reuse, then it has to be disposed or in a safe and environmentally sound manner. So that is the TSDF, temporary storage and disposal facility for hazardous waste. If we cannot recycling or reprocessing, hazardous waste be disposed in a safe and environmentally sound manner. For this purpose, a scientifically designed and established TSDF is required. So, state government occupier operator, because occupier and operator, they are handling the hazardous waste, and state government, and it is also the state government responsibility for identification of TSDF in the state. Then the TSDF has to be designed and implemented as per the guidelines of CPCB, and also after obtaining approval from SPCB. SPCB has another duty to monitor setting up and operation. So in the setting up, the installation or establishment stage, the SPCB has to monitor. Then the operator shall be responsible for safe disposal and post-closure phase. Then operator shall maintain record of TSDF information. These are the highlights of 2008 hazardous waste management and transport movement rules. So nothing much to describe because now it is HOW management and transport movement rules. So slides 67, because that has to be mentioned, because how this HOW MGM rules, the new rules 2016 originated, because of case filed in the Supreme Court complaining the violation of fundamental rights due to the effective, due to the non-implementation, the lack of effective implementation of hazardous waste rules established in 1989 and 2008. Though the hazardous waste management rules came into existence in 1989, they were never implemented in letter and spirit. Due to alarming situation created by illegal dumping of hazardous waste with generation and serious and irreversible damage as a result thereof to the environment, flora and fauna, health of animals and human beings. A petition approached the Supreme Court under Article 32, complaining of violation of Article 14 and Article 21. Article 21 is the right to live. So the Supreme Court ordered in an earlier judgment that right to pure water, right to clean air, and right to clean environment are coming under Article 21 of the Constitution, that is right to life. And this case, the petitioner relied upon the Basel Convention, which was signed by India on 15 March 1990 and ratified on 24 June 1992. So even though it was signed by India in March 1990, Our hazardous waste management rules 1989 did not make a commitment to the convention. So because of this court intervention, the 2008 hazardous waste management and handling transboundary movement rules came. So in this case, the Supreme Court issued the following orders. In 1997, Supreme Court ordered to prevent serious adverse consequences to the environment due to the non-implementation of hazardous waste. So they observed that an appropriate committee deserves to be constituted to ensure that needful is done to arrest further growth of the problem. So they constitute a high power committee. That is headed by MGK Menon committee, and they submitted a report to the Supreme Court in 1998. The report had highlighted the industrial operations, solid, liquid, gaseous waste, which results in generation of the hazardous waste. So far, the pollution control boards, not only here, in all the states and the CPCBs, try to control pollution by implementing Water Prevention and Control of Pollution Act 1974 and Air Prevention and Control of Pollution Act 1981, and also some interventions by EP Act. So, as rightly pointed out in the SPC, the main problem is the generation of hazardous waste from solid, liquid, and gaseous waste. So after that high power committee report, Supreme Court constituted a Supreme Court Monitoring Committee, SCMC. So SPA high power committee report showed 80% of countries hazardous waste generated in the, as I have already mentioned, Maharashtra, Gujarat, Tamil Nadu, and Andhra Pradesh. So the Supreme Court directed or give the power to this Supreme Court Monitoring Committee to oversee the direction of the court are implemented timely. So it would be open to the monitoring committee to co-opt a representative of the state government or SPCBs or any other person or authority as the committee may deem fit and proper. So they have given the composition of the committee also. Dr. D. Tyagarajan as chairman and the committee asked the committee started functioning in 2014. The committee asked the state government, here the Kerala state government, and the board takes steps on various issues regarding disposal of hazardous waste, regarding common treatment, storage and disposal facility, inventory of hazardous waste, and water supply to Elur. Elur is the industrial. That time it was an industrial, still also an industrial belt of Kerala. And Elur is at the coast of Periyar River, and Periyar, on the banks of Periyar River, the longest river in Kerala, the lifeline of Kerala. 25% of the chemical industries are on the banks of Periyar. And as per the Supreme Court Monitoring Committee, a local area environment committee was formed, and they did an environmental audit, mostly in Elur area. So they made an inventory of hazardous waste, categorizing the industries or hazardous waste generating units in large, medium, and small. So, as per their auditing, the total hazardous waste generated is much more than the waste estimated by the State Pollution Control Board, because that is a people participate, their people's representations, industries representation, and environmentalists. So their estimate is more, because a regulatory body can estimate based on clear estimation or based on documents and assessments. This is the estimation of hazardous waste generating industries in Kerala. That was estimated in 2007. According to this, the number of units generating hazardous waste is 524. Now it is much more, because now not only hazardous waste, other waste also included in the rules. So large 66 numbers, they constitute 12.6% of the hazardous waste, total hazardous waste generated. Medium 63 number, they represent 12%. And 75% of the hazardous waste generated from 395 small industries. So this is the district-wise number and number of hazardous waste generating units in large, medium, and small. This is the graphical representation, slide 80. So then, again coming to the TSDF, temporary storage and disposal facility in Kerala. This is a very good achievement in Kerala, because as for the, according to the link, or from the great pressure from the Supreme Court Monitoring Committee constituted by the Supreme Court, and from pressure from the public, and also understanding the necessity of TSDF by the industries. Common Treatment, Storage and Disposal Facility, KEIL, Kerala Environment Infrastructure Limited, established a secured landfill for disposal of hazardous waste generated in the states. So it was established in 50 acres of land at Ambalamugal, that land from FACT. That envisaged capacity of secured landfill is 50 tons per annum. Quantity estimated for stabilization and treatment 25,000 tons per annum. There is a criteria stipulated by the Central Pollution Control Board for hazardous waste landfill or for establishing TSDF. And that 50 acres land of FSCT satisfy this criteria. There won't be any lake within 200 meter, no river within 100 meter. It shall not be a floodplain area within a 100-year period. No highway within 500 meter. Shall not be any habitation within 500 meter. There won't be any public parks within 500 meter. Shall not be wetlands. Not a notified zone by airports. There won't be any water supply well within 500 meter. Won't be in CRS area. So, this is the criteria for using the material for the establishment of TSDF. The first, the sub base is, the bottom base is compacted, and above that 450 mm clay liner. Then above that SDP 1.5 mm SDP geomembrane line. So that 300 mm clean river bed fine to medium sand. Then 2 GSM non-woven geotextile. About 900 mm thickness compacted clay. Above that again 1.5 mm SDP. Then 200 GSM geotextile. And above that a layer of clean river bed coir sand. Then again 2 layer 250 GSM geotextile, 200 GSM non-woven geotextile. Above that the waste is. Here see the waste material is added for that. TSDF is established in a very scientific and environmentally sound manner. There is provision for leachate collection, sampling, and groundwater is monitored in particular locations by digging well, that is groundwater monitoring well. And TSDF is constructed in a minimum area of 20 acres over a period of 20 years. That means minimum post-closure maintenance period 30 years. Central Pollution Control Board and Ministry of Environment, Forest and Climate Change specified limits for acceptance of hazardous waste or direct disposal to secured landfills. on arriving the waste or before collecting the hazardous waste, KAL analyze the waste and ensure that the waste is suitable for disposal in the secured landfill. The waste is suitable on primary analysis. They will try to stabilize the waste. This is already in the picture. Scientifically designed secure landfill with double liners and leachate control collection, removal and treatment system. One for non-container is liquid waste or waste containing pre-liquids must not be directly placed in a landfill. Ensure TCLP test. TCLP means toxicity characteristic leaching procedure. That is the TCLP test. They will ensure that the SDF authorities ensure that TCLP test characteristics are complied with. Ignitable or reactive waste must not be placed in landfill. And the operator or occupier has to maintain proper records for indicating exact location, dimension of each cell, its contents, and environment monitoring data. So, this is all about this hazardous and other ways management and transboundary movement rules. I have already mentioned that Environment Protection Act 1986 is the act behind this, because this act provides the protection and improvement of the environment. And this EP Act establishes the framework for studying, planning, and implementing long-term requirements of environmental safety and laying down a system of speedy and adequate response to situations threatening the environment, because it is an umbrella legislation. I think my colleagues have already mentioned the constitutional framework and the international commitment to the international conventions. You know, 51 AG, that they must have mentioned, because 51 AG is an amendment made in the Constitution in 1974. Because every citizen has a duty to protect the environment, including forests, rivers, lakes, wildlife, and to have compassion for all living creatures. And similar one is 48A, that is the responsibility of the state. And 51 AG casts a duty on all citizens. 48A casts a responsibility on states to protect the environment, including forests, rivers, lakes, and wildlife. And Article 21 is the right to live, and the Supreme Court mentioned in the very earlier order that right to pure water, clean air, and clean environment is the right to life. So, and the first international convention, Stockholm Convention, was duty or responsibility to all countries to safeguard the or protect the environment by applying precautionary principles, polluter pays principles, and principle of sustainable development. So the three important principles of environmental protection by states and pollution control boards and the NGT, National Green Tribunal, are precautionary principle, polluter pays principles, and principle of sustainable development. But in handling hazardous waste, there are some other principles are also mentioned by a committee constituted by National Green Tribunal in 2017. And the committee mentioned in their report, in addition to these three principles, there are duty care principle. That is to prevent the escape of waste while it is in the possession of the holder and while it is being held by others after being transferred. To ensure that waste is only transferred to person authorized to receive. Then some cooperative principle, because for handling hazardous waste, there is cooperation of various agencies are required. Then an important principle that is not only in hazardous waste, handling of all waste, a principle of waste management hierarchy is required. Most favored is prevention, then minimization, third reuse, then recycling, then energy recovery. If all these 5 phases, then only disposal. So least priority is disposal. First is, this is also in 5 R's. 5 R's we have, but mostly we hear 3 R's. Reuse, recycle and recovery. But 5 R's, it is refuse. First is refuse, means we are refusing waste, no waste. Then if it is not possible refuse, then reduction, reuse, recycle, recovery. These 5 R's are failed, then only disposal. So principle of waste management hierarchy, that is least hierarchy for least significance for disposal. First is refusal, then reduction, reuse, recycle, and all these 4 phases recover something, mostly energy from the waste. All these 5 phases, then disposal. Then another principle is principle of batch, principle of best available technology. Best available technology for management or handling of hazardous waste. So thank you. Thank you, sir. Thank you all students. Any question?
Thank you, sir, for your valuable talk. Now the session is open for discussion. If there is any query, you can ask or you can post it in the chat box. Sir, I have a question that which type of lining material, that is basement lining material, is used in TSDF in Ambalamugar? Can you tell us about that?
This TSDF, first thing is clearing and maintaining, and also this leveling and compacting. After that, clay liner is used. Clay liner, particular thickness is here in this that is 450 mm. The clay liner. That was in the layer was mentioned in some slide. Then above that clay lining, 1.5 or 2 mm SDP line, high density polyethylene. That is used. And above that high density polyethylene line, there is a 300 mm thick of clean river bed, fine medium sand. So clay lining, then SDP lining, then sand lining. Above that, here in Ambalangal, it is non-woven geotextile lining. And again, clay or soil lining. So clay lining, then SDP lining, then sand lining, and again clay lining. Then again, above that, SDP lining, high density polyethylene lining, geotextile lining. Then above that, further sand lining. Then geotextile lining. So the lining is made by first compacted base, then clay lining, then SDP lining, sand lining. Once more clay lining, SDP lining, and sand lining.
Okay, thank you, sir. Thank you so much. Next question from the audience side.
Thank you, Thrideep sir, for the nice presentation. We have some issue with the PowerPoints because we are uploading from here and you are actually speaking from there. So there is a communication gap between us.
Yes.
I don't know whether it has created some problem to the audience. Regarding anyway, it was a very good presentation. We could hear a lot about the hazardous waste management in India, different types of waste management. And in the beginning, you have mentioned that about 80% of the waste is actually generated by 4 states in India: Maharashtra, Andhra Pradesh, Tamil Nadu, I think Gujarat. I want to know whether these states are properly treating the waste or properly managing the waste. And you mentioned that in Kerala, only 2% actually generated,
Less than 2%.
and around 72,000 tons last year, 2019. So whether we are actually properly managing the waste in India, the mechanisms or the technology available in India is suitable, sufficient to properly manage the waste, particularly the hazardous waste. Okay. Can you give some explanation for what I mentioned right now? Am I audible to you, sir?
Yes, sir. Sir, it is actually this 80% of the total waste is from these 4 states. First is Maharashtra, then almost about Maharashtra, this Gujarat is also producing, then Andhra Pradesh, then Tamil Nadu. Here, even though we have only one TSDF, that is KAL in Ambalamugal, according to our quantity, that is almost sufficient. We are insufficient only in biomedical waste, common biomedical waste management facility. We have only one, but our neighboring states have more than one. But in other states, this TSDFs, they have lot of TSDFs, even though those TSDFs are not sufficient, because these states have 10 to 15 times of Kerala's hazardous waste more. But the number is that much not high. So, and also this hazardous waste, I have mentioned only this the grading convention, Basel convention. Actually, India has commitment to 4 conventions: Basel convention, Then Rotterdam Convention of Pre-Informed Consent. That is, pre-informed consent is pre-informed consent for import and export. Then Stockholm Convention for Persistent Organic Pollutants. Then Minamata Convention on Mercury. So these conventions we are coming. So these mercury waste, then TOP waste, persistent organic pollutants waste. Considering all these hazardous waste, these states are not committed to the management of hazardous waste properly. Because we don't have any, not much POPs, persistent organic pollutants. We have only one that HAL, and insecticides, but these pesticide units are more in other states. Also, we don't have mercury waste, and also large chemical industries. We don't have much. These chemical industries and also common effluent treatment plants generate hazardous waste. These CETPs are more in other states. In fact, we want more CETPs. There is more CETPs, then there will be hazardous sludge. There will be more waste. Now these hazardous wastes are going into the land and water bodies along with the wastewater. So in other states, more CETPs, so more hazardous waste. Considering all these aspects, these POPs, mercury, and other chemical industry generating hazardous waste, the management has to be improved much in other states.
Okay, sir. I want to know one more thing. You mentioned that hazardous waste cannot be disposed of; it has to be reused or recycled, and so something like that in India. But at the same time, you have shown that some forms like form number 7, form number 8, for the export and import of hazardous waste from India to India, and we need a permission from Ministry of Environment and Forest, Government of India, something like that. So I don't understand these two things. So earlier you mentioned that we cannot export or we cannot import hazardous waste. At the same time, you have shown some forms. Can you explain that particular thing?
Sir, it is a very, very good question, and it is the center of this rules also. Because hazardous waste, and also in this answering this question, we have to go much into the precautionary principle. Because the hazardous waste we have defined as those waste having some 5 characteristics, and also some waste are listed. Because these characteristics and listed, because already these hazardous wastes are analyzed and found that it is hazardous, and its or disposal or reuse or treatment methods are specified. But in case of waste which are deemed to be potentially hazardous, such waste should be classified first, managed, and disposed as hazardous waste. As long as the confirmation of their hazardous or non-hazardous nature is pending or anything. So, if a waste are having hazardous constituents or hazardous characteristics, and we are of the science or technology or the knowledge is not developed to how much hazardous and how can it be disposed. It is unclear. Then it is considered as hazardous. So, some waste earlier classified as hazardous after developing some technology and after understanding its hazardous nature, later it was considered as hazardous waste can be recycled and reused. Then it need not go to the disposal site. If it is unclear, it has to go there because we cannot dispose this into the environment to harm the human health and environment. So in those cases where there is clarity in hazardous nature and its potential to harm the environment, and if there is technology to reuse and recycle and recover, then those waste will be allowed to import and export. And no waste is imported or exported for disposal. So only those waste can be reused and recycled. And there is scientific technology available for reuse and recycle and for new products. Only those forms are applicable and only authorization is given. Sir, it is clear.
Yeah. Thank you, sir. Now I invite the participants to ask their questions, queries related to hazardous waste management. So this is a very important topic as far as India, Kerala is concerned. We have been facing a lot of issues related to the hazardous waste management. So the basic concept and the various laws related to hazardous waste management, how it is managed in India, Kerala, all these things covered here. I request all the participants.
Sir, I wish to know how, sir,
Yeah.
I'm Dr. Jaya. I wish to know how the e-waste is managed by our pollution control board, e-waste management by our state.
Madam, the e-waste
Sir, can you-
management is handled by another rule that also came in 2016, e-waste management rules. Earlier, it was in some portion of the hazardous waste management. It is separate waste management rules. There are 6 waste management rules came in 2016. Solid waste management rules, plastic waste management rules, construction and demolition waste management rules, biomedical waste management rules, e-waste management rules, and hazardous waste management rules. It is separate rule, and like this rule, there is all these aspects, this name, definition, and management, and this forms and
Sir,
schedules.
how our pollution control board is managing this e-waste? That I want to know.
Yes.
In Kerala.
Yes. Like all these rules, Pollution Control Board is the regulatory authority to enforce the e-waste management rules.
Sir, are we doing any recovery of heavy metals from this hazardous waste and e-waste? Specifically, e-waste, usually they contain some heavy metals. And how do you have any steps or you're recommending any steps in the pollution control board? They are doing some recovery process, or they are giving some instructions for the recovery of heavy metals from this e-waste.
Yes, e-waste is also managed by Kerala State Pollution Control Board. So the first thing is this e-waste management collection centers. Actually, this e-waste mostly from e-good centers, e-good agencies, electronic goods. So
So it is not audible.
Sir, it is
Naomi,
not audible.
Not audible.
I think some network issues there. Sabu sir?
If no more questions from the participants, I request Shri Naomi SS to conclude the session.
Okay,
Thank you.
sir. We had a very good presentation on the topic hazardous waste management by Shri Thrideep Kumar MP. He has discussed us about the hazardous waste management practices and related issues and their dimensions, and the rules and regulations, policies related to the hazardous waste management, and role and duties of authorities in this management of this hazardous waste, and responsibilities of the occupiers, and transport and management criteria for and strategies for the hazardous waste management. Behalf of the organizing committee, thank you, sir, for your valuable presentation, and I thank all the participants for attending this session. All the PPTs will be shared to the participants very soon. Thank you one and all.
Thank you, Naomi, for the concluding session. So on behalf of organizing committee, on behalf of University of Kerala, I thank Shri Thrideep Kumar sir for the nice presentation. Also, I thank Srimati Naomi SS for efficient chairing of the forenoon session. So our afternoon session starts at 2 p.m. We have a presentation on industrial solid waste management with a special reference to biocomposting by Dr. Salom Nanatanga, Professor and Head of our department. I request all the participants to be in the session sharp at 2 p.m. itself. So after the afternoon session, we have a small voluntary function. Thank you. We will meet at 2 p.m. Thank you, Thrideep sir.
Thank you, sir.
Thank you very much. Okay, thank you.